typed as by Justice Honorable Justice D. Das and Justice Panigrahi, my lord.
ସେଟା ଜଲ୍ଦି ନ କଲେ ତାଙ୍କର 3-4 ଦିନ ଅଛି ନା
And Monday, Monday.
In my case, I was mentioning the opposite parties have no objection to my tender, but I've been mentioning since because there are two matters. Tagged. One matter is disposed of. My matter.
I don't know all the slips which were filed
Yes, madam.
up to Wednesday, I think. Those slips have passed some order this way or that way.
Well, it's that.
Thursday, as Friday, I have not taken up. Up to Thursday, I have not.
This can be taken up because I have been mentioning this in long. The opposite
Your
party
mentioning is not
object.
important.
whether it is urgent that is
Yes,
important.
madam.
Not
Urgent,
Because
maybe urgent according to you.
Well, maybe I'm not able to express it in writing. I can express it if your lordship allow me for 30 seconds at least. Madam. There two tagged matters were there. One was withdrawn. Second, in this first case, opposite party.
MCL?
Yes, madam.
Okay.
So lordship may kindly take it up on Monday. In orders, at
We will
least
see.
it can be disposed of.
We will see, give you.
Maybe permitted to
That
mention.
also could have been disposed of. You unnecessarily are
No, it's because
Anyway,
another
anyway.
fourth party came inside.
Alright,
So that's why I wanted your lordship to hear me.
Give you a slip.
Maybe permitted to mention.
Admission matters, my lord. Return of PMD. I have completed the tender work successfully, but they have not returned.
Please,
My lord, this is my matter is the fresh admission. Unauthorized construction is going on the playground of the students. So my lord, this is the interest is being hampered. So my lord, kindly.
if the constructions are illegal,
My lord, it's just
constructions
my
can be
lord,
demolished.
because unauthorizedly. Only your lordship take up on Monday
There are so
because
many
during
things,
Puja holidays they will
Mr.
complete.
Council, there are so many things happening in the estate unauthorizedly. It is not that we can see every
Yes.
illegal
But my
aspect.
lord, I will show
If
my lord.
finally, no,
I-
there are urgent matters.
Yeah, urgent matter, my lord, because the during
Mr. Council, are you representative of association? Do you represent association?
my lord,
You go and tell your members that this matter is more important, more urgent than other matters.
because the public.
If they pass a resolution, we will take up.
Yes, my lord, because public
Mr. Raj,
interest, my lord.
You have given the memo.
Yes, yes.
Considered.
Oblige, my lord, see.
Yes.
My lord, tender matter, my lord, urgency. Tender matter ଅଛି.
Give-
ଲେଖିଛନ୍ତି ତ? ଲେଖିଛନ୍ତି?
Lordship, regarding the construction of post office. Regarding the construction of post office for public at large.
That is not urgent, Mr. Council. How is
People are
that
facing
urgent?
more.
Later. We are trying to take up matters as much as it is possible.
My lord, fresh admission notice till date has not been issued to challenge the order of under single bench.
Wait.
Madam.
Not now, wait.
Lordship, pardon to mention item number 6. Item number 6 on behalf of Mr.
Lord, I have been requested by the other side also. And I am also joining the prayer that let it come after vacation.
All right.
Much obliged.
Item or 11 urgent demolition matter may be taken up today. 11 item.
Item 6 or 2013 matter that restore delay condoned with the Supreme Court and remanded.
Matters under the heading for orders. Item number 21.
There is a 90 days delay.
Yes. Someone is appearing.
No.
First
No.
time.
First time. Notice.
Item 22.
Item 22, madam, this is a job contract pension matter. Similar matters have been notice has been issued and some matters have been stayed before the honorable apex court. There is 271 days delay.
Can we tag it to some case?
Yes, that is 432 of 2021.
32 of 2021.
Madam.
Is 6 weeks.
Yes, ma'am.
6 weeks.
No.
Did I was after 6 weeks? Let them do that.
Item 23.
23 also same.
And both are same.
Yes, ma'am. Here 150 days delay.
All right. Could you please repeat that rate appeal number?
4/32 of 2021.
Is that fixed to a specific date or?
No, my last, on last year it was fixed after 8 weeks.
And 24,
But 24, there is a delay of about 174 days.
Pardon me, Lord. In item 24 and 25, I have been instructed to appear on behalf of the.
Sir, copies. Honorable sole or retapil, I can serve copies on my
I
friend.
will file my objection. My Lord, I will file my objection.
can we condone the delay or you want to file objection?
I want to file objection.
G.R. Sethi, waiving notice, Mr. G.R. Sethi appears on behalf of sole respondent or
Yes, Lord, sole respondent.
of the sole respondent. Copy of the IA be served on him by 7/10/2024. List on. This Saturday, so it has to be on a Monday, 11th,
Reopening 28th October.
28th. Okay.
21st.
Or 28th, 28th, list on 28th for fresh admission. Objection if any shall be filed in the meanwhile.
I may pardon, my lord, that
Just one moment.
sorry, ma'am.
Both these cases,
25 also.
no, 24, 25, are they similar?
Yes, Lord,
Similar,
similar.
similar.
Narsu Pradhan, Lord, so that judgment of Narsu
No.
Pradhan.
These two can be tagged thereafter other.
Yes, Lord, yes.
Yes.
Your Lordship also direct my.
I will give copy of appeal memo.
Read of appeal memo.
And I will give it, don't worry.
That I was mentioning the 4/32 of 2022 instead of 21 to 2022. Yes.
Alright.
That is adjourned to 5th November.
Okay, so we can say 5th na enough time hoga nahi, 4 weeks ho jaye.
5th November.
Then return within 4 weeks. 4 weeks total hoga. Oh, nahi.
3 weeks.
3 weeks. Returnable within 3 weeks tale kar do list on 5th November. Yes.
22 and 23. Item 26.
26 में 330 days delay. This is the judgment. Your lordship has already quashed that, just basing on which this order has been passed. Your lordship has already quashed it. So notice to go on limitation.
How many days?
330 days.
Item 27.
27 में 100 days delay rehabilitation matter.
Some defect you have not removed.
I will remove
What
your
is the
defect.
defect?
Yes, my lord. Within three.
You're appearing?
My lord.
I am permitted to file the objection to the.
How many days delay, Mr.
100 days.
100 days. You want to
Yeah.
file objection?
My Lord.
We can condone giving some.
My Lord.
We can condone, even otherwise we will condone.
I will file objection, my Lord.
100 days delay, what will you file?
100 days delay, we will condone.
After your Lordship may grant 1 week time, I will file objection.
All right.
So Arjun, he's already appeared, Acha. Please remove the defect. What is the defect?
I'll, no, here more than 100 days, not 100.
7.
Have you filed any contempt application?
My Lord.
You have
112
filed.
days.
You have filed contempt application.
My Lord.
So you will not press that.
That is.
You cannot press that.
My Lord.
Yes. This application has been filed for condemnation of delay of 112 days in filing the writ appeal. Mr. Arjun Charan Behra, waiving notice, has appeared on behalf, waiving notice, Mr. Arjun Charan Behra, learned counsel, has appeared on behalf of the respondent. Copy of the IA be served on him. Course of the day or
In course of the day.
in course of the day? List the case on. Wait. What is?
Mobile number.
28. List the case on 28/10/2024. Objection if any shall be filed in the meanwhile after serving copy on the learned state counsel. Full stop. Mr. Behra, learned counsel for the respondent, submits that although he has filed a contempt application, he shall not press the same till the next date. He shall not press the same during pendency of the appeal. All right. You have to file either the certified copy or that
Yes, my certified copy.
dispensing with.
I'll file certified copy.
28.
28 में 90 days delay.
Yes, 90 days.
90 days delay, your lordship may tag this matter along with item 23. That is, this is what the,
Item 23.
my lord, similar.
So again, that will be written over 3 weeks. List on 511.
Yes.
Yes.
Item number 29.
29 also same.
29 same. Already.
That delay 300 days.
The application for condemnation of delay literacy. Yes. 3 weeks.
Item number 30.
Item 30, my lord, pension of block grant employees. There is a delay of 120 days.
Connected matter.
Connected matter, your lordship has fixed it to last, perhaps on 25th September, it was fixed. Thereafter, no date has been fixed.
All right.
A batch of matters, your lordship may remember that 800 matters.
You remember any number?
Yes, I will give that number. My
All right. Check kariye according to the date.
800 cases.
three appeals. It was listed in a special list before my lords.
That was coming in a special list
Yes.
last week, I think.
Last week, it was listed on 5th October.
What is
25th
the-
September.
What is the issue involved?
That is regarding that pension of block grant employees. One,
All right, we will see. And whether the cases arising out of that Senapati matter,
your lordship has already rendered that judgment. That in
similar matters are pending.
no, so
No.
2-3 matters are similar matter that were disposed of when your lordship passed that judgment. Thereafter, 3 matters were disposed of.
So nothing is pending.
Mr. Yeah,
Hello.
item 30, we are listing after vacation along with the batch.
Yes, my item 30, 31, 32, 3 matters are similar, your lordship.
List on 5th 11/2024 along with so and so and batch to be taken up at 2 p.m.
Yes, that was fixed for 2 p.m. That matter was fixed.
Fifth. Fourth, Karma. Fourth is also.
Maybe
11th onward.
30, 31 and 32.
30, 31, 32.
To be taken up at 2 p.m. Batch, could you just give one number?
I'll find it.
Confirmation of this and consider the type of admission.
At the time of admission. What a draft.
The leading case on that bat is W29492020.
49 of 2023 of this. 2949
Yes, ma'am.
2023. Oh, you gave it. Okay.
Item 33.
33, my lord, 120 days delay. Rehabilitation notice.
Rehabilitation, or can it be disposed of in terms of that?
So no one has appeared for that reason.
Okay. Dispensing with, please, Post of dispensation of filing of certified copy in this issue notice. So these are being listed, I think, not in a batch. So as and
No,
when
not
somebody
because
appears
all
for it.
some matters after their
Okay.
appearance, you'll also be disposing.
Only 6 weeks. Return of 4 week list after 6 weeks. Now, how many days delay?
120 days delay.
Item number 34.
34 job contract matter. In the similar matter, your lordship has already issued notice. And here 350 days delay. A batch of writ appeals were also dismissed here on the ground of limitation that was challenged before Honorable Apex Court, and Honorable Apex Court has stated that directing not to grant pension. Here pension has been granted to the job contractor after their regularization, taking into account the minimum period of service. Now they are claiming the entire period of service is to be taken into account for the purpose of pension. There is a 350 days delay, your lordship.
Similar matter, anything
Yes.
posted to any particular
A
date?
particular date has not, because your lordship has.
Give a number, please.
I will give the number.
For that day along with.
Item
35?
35.
My 35, there is a delay of 110 days.
What is this matter?
This is regarding my promotion during pendency of departmental posting. You also passed
Disposed of.
on similar case. You already passed judgment that in that Joseph Barry case, notice to go with limitation.
Taken notice has to go that the filing of certified copy that can be allowed. Again, 6 weeks list. So date, what is the date? 25/11. Both. Yes.
Item 36.
My item 36 and 37, the lordship may think that is similar to 30, 31, 32.
5/11.
11,
No, no.
11, 2 payment.
Sorry, 11/11 already. Similar to 30, 31, 32.
So, sorry, my lord, not 36. 36 is same, not 37. Sorry, my lord.
Okay.
Not
37.
37, my lord, the counting of the past service. 36 the same, 36.
37?
37, my lord, counting of past service. The periods on the contractual service, Honorable Court has directed to count that past service for the purpose of qualifying service. So the limitation is there 245 days. Pension rules.
I think it can be counted for qualifying service, or they want more.
No, what has happened in this case?
Yes.
What has happened in this case? They are appointed on contractual basis. So new pension rule come into force with effect from 1/1/2005. They were regularized after 2005. So the Honorable Court had directed their contractual service is to be counted for the purpose of qualifying service. Unless they came to the regular establishment, they cannot be converted to regular employee status. Our case is that.
Yes. Please. Your case is that?
Our case is that the date as they are regularized after 1/1/2005, they are not covered under OCS old pension rules.
See, so many things will depend on the what you were doing before they were brought in the regular establishment.
Yes,
whether GPF was being deducted or not, whether.
yes, that happens. In fact, there is no deduction from the GPF till their regularization.
This is what we are saying.
Yes, till their regulation, there is no deduction.
Just a minute.
Orissa pension rules must be a small compendium. Yeah. Thank you.
All right, that's.
Just 6 weeks. So no similar matters pending.
No, madam.
This something that P3 and again 6 weeks. So that counts to how where 6 weeks?
25th email.
Item 38.
30th madam, 198 days delay, rehabilitation.
Item 39.
Yes, delay.
But 38, madam, 39 also rehabilitation. Madam, there is delay of 282 days.
Yeah.
Madam.
Rehabilitation matters, can't it be disposed of in that that Bindu Sagar?
Yes, madam, that can be disposed of. That I have given also last time Mr. Samal was appearing in that case.
Appeared.
He had appeared that your lordship can dispose of those matters in light of that, and my lord's judgment order is there. It can be disposed of, but there none appears.
39 is 39. That is 39. Have you called out 39?
It is 39.
Yes,
39.
39 is that rehabilitation.
All right. So 38 and 39 both are rehab.
Yes, yes, madam.
Okay. First one 198, second.
Second is 282 days.
22. It is not right.
Item number 40.
In item 40, 210 days delay.
But in this case, I have already entered appearance for the respondent. I'll file an objection, my lord.
How much?
210 days.
What is the issue?
That's, you dismissed pursuant to disciplinary proceeding. That was set aside and remitted back to the discipline of the
So you have appeared, you want to file a objection?
objection to the limitation bets.
How many days?
210 days. But they're not at all explained.
I'll serve copy in course of it.
Has appeared on behalf of the sole respondent, copy of the IA is served on him. Course of the day or Monday?
In course of the day.
Of the day, this is the case on 11/11. 4th. On 4/11/2024. Objection if any shall be filed in the meanwhile.
My name may be reflected in the call list.
Yes. Old matter, item number 1.
That matter, every day that is urgent. Item 1, that matter, every day is urgent. I am
What is this about?
He was unwell. So we
yes,
have granted
because of that. And and very interesting was that man is of 80 years. So
Here and his father, that is.
and that son is ill. Tell us, may grant some time.
Twice, I think you have said.
Thrice, I am praying time for him. Man.
Thursday.
Last week we had orders, all the orders that also.
Then why should we not? You may have missed your time. On the-
No,
no,
we had said, if adjournment will be short, but we will inform the records.
Thereafter, he has appeared. But on
They
that
also
day,
there
did
is
not
no
reach.
representation on behalf of the petitioner.
No, I am for the.
Last date passed a reason order,
Yes,
putting the last order. Then
yes, my lord.
You are for the?
I am for the appellant, my lord.
Oh, you are.
Respondent is not appearing, my lord.
Oh, this is writ petition.
Yes.
He's making submission.
All right. There is no representation. Today also there is no representation on behalf of. And today there is no representation on behalf of the party. Number 1.
Yes.
Was it party number 1? This is matter on Thursday.
Thursday is holiday.
Ah.
The website. Common purchase for October. That's
Item number 2. Item 2.
It's a matter where the order of the Central Administrative Tribunal is under challenge. My lord, this is a matter where the issues were the person who is before your lordships as the appellant, he has challenged the selection process of opinion conducted by the authorities in pursuance of an advertisement, where OP number 5 has been selected. Here the fact is, both petitioner, the appellant as well as the present OP number 5, both were in-service candidates. In-service candidate means they were lift operators under the CPWD with the very same organization for so many years. And instead of regularizing, they had issued that advertisement. Both of them participated, and both of them secured the same mark, full marks they have secured. But the petitioners, the present appellant challenges that the application of OP number 5 was ineligible as because he didn't submit the documents which the advertisement requires as a precondition along with the application, which the authority have found out during the selection process, and they have noted it down. Despite the said fact, finally the selection went through, and ultimately OP number 5 was selected on the plea that he is having more experience than the petitioner, than the present appellant, though in fact that is also wrong. In fact also that is wrong.
And what about you?
My lord?
What about you?
My lord, so far as the experience is concerned, I have gathered more.
No, whether you are still working.
Still working, he is also still working. Only thing is there are 2 posts. There are 2 posts, and despite that, my lord, he is working as lift operator, I have been working as a lift khalasi with the temporary status. That is the difference. But as per the sanction strength of the of very organization at Bhubaneswar under the CPWD, there were 2 posts of lift operator. And the requirement as per the advertisement, my lord, he didn't met. Despite that, he was found, he was considered eligible. And that was the specific point I had taken in my writ petition. When I challenged the matter before the tribunal also, I have specifically challenged that the selection process is also wrong. But the tribunal, for the reasons best known, my lord, it could not accept that without any reason. That both of us are working as lift operator. That also they admit. Here they have filed a counter, 2 paragraphs, my lord. In 1 paragraph, they have stated about myself, and they have clearly stated that I have started working from 1/6/1990. On the other hand, he started working on 1/8/1990, 2 months after my joining. And I had discharged more number of years, but the requirement is only 1 year. My lord, so far as the advertisement, the fresh advertisement is concerned, it only requires 1 year experience as lift in operation of lift. We had put in much more number of years. So the experience, whether somebody has put in more experience or somebody has put in less experience, that hardly matters, subject to satisfaction of basic eligibility. Since he didn't satisfy the eligibility.
No, you were eligible, he was also eligible, but because he had more experience, there must be some criteria for.
There is no such criteria available under the advertisement. And
even if there is no such criteria disclosed in the advertisement,
yes,
when the selecting agency, recruiting agency has some material before them, then they have to decide as to who is more suitable.
My lord, I'm sorry, my lord. The material, the very contention that he is having more experience than me,
incorrect.
Serving under the very same respondent, that itself is factually incorrect, because I had put in, as per their own admission, more number of years than him. They do admit simultaneously that right from my date of appointment, I had put in more number of years of more service than him, but still a wrong finding has been arrived at, a wrong decision has been taken, that as if he has acquired more experience than me. And moreover, my lord, your lordship, when it's a new appointment altogether, he has to satisfy the terms and conditions of the advertisement, which mandates that he should have submitted all the documents in support of eligibility. He didn't give. That is what my contention I have raised, and that has not been rebutted. But my lord, as your lordship have rightly pointed out, whether both of them are working or not, fact remains both of them are working. There are 2 posts, but they have accepted him as continuing against one such post, and they have left me, and while the other post is lying vacant. And all through I have been continuing as the lift the khalasi with temporary status, and before the tribunal.
So you are still working as a lift khalasi?
Yes, my lord. That, and your lordship may kindly see, before the tribunal, my lord, it's a second round of litigation before the tribunal. It was the second round of litigation before the tribunal. When the first round of litigation, I went before the tribunal claiming that I should be extended with the benefit of regularization under the scheme floated by the government. They took the stand that the post against which I am claiming the benefit is a Group C post, that is lift operator. So you be extended with the benefit. My lord, I am with the lordship's permission, may I be permitted to repeat it? My lord, before the tribunal in the first round of litigation, when I went there with a prayer that I should be regularized because I have been continuing against the post of lift operator, they took the stand saying, denying the prayer made by me, that since you are continuing as a lift operator, which is a Group C post, the benefit as is extended under that scheme is not available. Despite that, the tribunal directed, you consider his case because it has been continuing for so many years. Accordingly, extend the benefit of the scheme. Since in implementation of that order of the tribunal, they issued that order engaging me as lift khalasi. Now they are capitalizing on the said appointment, saying that once you had got before the tribunal and the tribunal directed us to consider, and we considered you as lift khalasi. Even if the post of lift khalasi was not available, then you are a lift khalasi and you cannot be treated as a lift operator. But one thing, my lord, I can put the question to myself. They are forgetting the basic thing, that the requirement here is operation of lift for 1 year, which they have clarified in their the counter itself. And prior to my appointment as lift khalasi, in compliance of the order of the tribunal way back in 2008, I have been working under them right from 1990 till 2008 as lift operator, operating the very same lift. So I have been operating the very same lift as an operator without any other person.
What was your grievance before the tribunal? What was your prayer?
My prayer was, I had gone before the tribunal with two prayers. One, my lord, there was a recommendation by my authority. In respect of both myself as well as OP number 5 for regularization against both the two posts.
Yes.
Instead of acceding to the recommendation made by my authority at Bhubaneswar for regularization against those two posts, accommodating both petitioner and OP number 5, when they published that advertisement, I went before the tribunal challenging the decision to go for the advertisement and the consequential selection process, as well as the recruitment made in favor of OP number 5.
No, according to you, you said that two persons were recommended. You
Yes.
And OP number 5.
OP number 5.
So recommended for what?
For regularization against the two substantive post of lift operator.
So that was mere recommendation.
That was mere recommendation.
Instead of accepting that recommendation, they decided to go for advertisement.
Single post. Exactly. By issuing a fresh advertisement. I challenge the decision not to regularize us and to issue that advertisement. That is one part. And I also challenge the
OP number 1 did not OP number 5 did not challenge.
He didn't challenge.
Because the recommendation was in his favor also.
Yes, also. Yes, my lord. He didn't challenge. I challenged, and I challenged both the advertisement as well and this consequential selection process selecting OP number 5. So on your lords may kindly also see.
Did you apply against the advertisement?
Yes, we are. Well, we were allowed to.
See, what was your praise? If there was any advertisement,
yes,
and according to you, they should have acted upon the recommendation made for regularization.
No.
Then, without applying, you must have gone to.
My lord, it is a fact that we both OP number 5 as well as myself both applied in portions of that advertisement. No. So, with regard to my claim for regularization, my lord, that has not been accepted by the tribunal.
That is difficult. See, therefore, we wanted to know the stage when you approach the tribunal.
Yes.
If you approach the tribunal after the selection process was over, then you have difficulties.
No, your lords may kindly see, I approached the tribunal.
If before the tribunal, if you challenge the appointment of opposite party number 5 also, selection of opposite party number 5, then you don't have any case.
My lord?
If before the tribunal,
yes,
you challenge the appointment of OP number 5 based on the selection process, then you don't have any case.
My lord, I am.
You cannot question the advertisement.
I'm deeply obliged, my lord. Your lordship is now putting that question to me. Your lordship is now having the observation that once I will have my claim for regularization, I should not have challenged that advertisement.
No, not that. You have participated in the selection.
You participated in the process of selection. So you cannot question the advertisement and process of selection.
Of so and so.
You can challenge that there has been discrimination in your case in the process of selection. That is
Yes, sir, that is what I say. That is what I say, my lord. So my challenge was on 2 counts.
So there was only one post. Don't say that there were 2 posts. There was one post which was advertised.
Yes.
Against which you had applied, he had also applied.
But his application, according to me, didn't was not eligible because he didn't submit the applications as has been found out by them and has not been reverted by them. Despite that, my lord, the entire selection was made only on the plea. Only, I will take your lordships to the documents, only on the plea that he has, as because he has put in more number of years of experience. So he is selected.
Was that a criteria? Was that a criteria?
That was never a criteria. That was never a criteria to grant any kind of preference. That is the entire case.
Where is the advertisement?
My lord, where is the advertisement?
Yes.
My lord, your lords may kindly see annexure page 49. That is available in annexure E/5 to the count. Your lordship got it.
E/5.
E/5 to the counter filed by the opposite party.
Oh,
Page 49.
Page 49.
Oh, yes. Yes.
My lord, may kindly come to.
Just a minute. Just a minute. Yes. So which qualification he did not possess?
No. Your lordship may kindly see. I would like request your lordship to kindly see column number 2, qualification. Second, should have worked as a lift operator for a minimum period of 1 year. There is no prescription anywhere in the advertisement to grant any preference for the.
Mr. Counsel, please, we'll consider that.
Yes, thereafter
See,
your lordship
if
kindly
the
see
qualification,
clause 5.
Just a minute.
Yes.
If the qualification is that a person must have secured 50% marks in matriculation. Now, if the committee has 2 candidates,
yes,
one having 50 and the other 60, then preference can be given to 60.
Ma'am.
So minimum eligibility means you have eligibility to participate.
Yes, ma'am. Your lords may kindly see clause 5. Clause 5, clause B. List of documents to be submitted along with the application. Clause B. Attested copies of all certificate in proof of age, educational qualification and experience. This was the requirement against which he didn't submit his educational qualification the documents.
But is there any educational qualification required?
Well, here in the advertisement, they have not mentioned about any qualification in particular.
That educational qualification must be for the purpose of age.
No, educational qualification.
Mr. Counsel, if he did not have any education, then how could he file any certificate in support of his educational qualification?
Well, he has claimed, and the authority have accepted that he has passed class 10.
All right, that's immaterial.
No, I am not there, my lord. He has not submitted any educational qualification document which the authority have found out in the selection process. Your lords may kindly come to.
But is the educational qualification required?
My lord? Yes, my lord. As per the so far as the post is concerned, so far as the post is concerned, minimum pass is this class 7.
Where?
Class 7.
Where is it?
It has not been prescribed in the advertisement. That I have admitted concept candidly. In the advertisement, they have not mentioned anywhere. But since it's a post under the government, even for a class 4 post, without qualification, nobody can enter into a job under the central government. And your lords, minimum qualification at least one must have is. So, but the requirement is one must submit documents in support of his educational qualification. Your lords may kindly see that is what they have found out as a deficiency while selecting page 19. That was pointed out.
Page 19 of what?
Page 19 did that they have given the select list. Annexure 5. The result of trade test of lift operator held on 3. It is annexure 5. It starts from running page 18. Your Lordship may kindly mark the third column, marginal heading, verification of documents and eligibility criteria. There, Your Lordship may kindly mark serial number 2 is the appellant over here before Your Lordships.
Yeah.
He has submitted everything. Next page, Your Lordship may kindly see serial number 6. Serial number 6. The OP number 5, Surendra Kumar Das.
Yes.
Educational qualification wise, both are same, pass standard A10 and qualification certificate not submitted. And this is the select list which was forwarded by the authority for consideration by the higher authority who took that decision. Your Lords may kindly come to page 20. Next page.
We have understood, Mr. Counsel.
My lord?
We have understood your submission.
Yes, ma'am. Your Lords may next page, Your Lords may kindly see the after this select list was prepared. Your Lords may kindly see next page, page 20. The matter was referred with the recommendation. Only 2 lines I will point it out to Your Lordship, subject to Your Lordship's permission. Your Lords may kindly see page 20. After leaving the first paragraph, last line, the attendance sheet and test results are hereby enclosed for further necessary action of issuing the letter of appointment from your end, please. Thereafter, the last line of the entire document. Though both departmental candidates, Sri Harichandra Das and Surendranath Das, had performed well in the trade test, hence it is requested to make an appointment of suitable candidate considering the CAT and Industrial Tribunal orders enclosed. This has led to the authority to exercise its discretion, not by the selection committee. This authority higher up elsewhere. Your Lords may kindly see next page, page 21. Your Lords may kindly skip the second paragraph. As they have scored same mark in the selection, now has to be decided on the experience of each candidate as lift operator. It is seen that the Harichandra Das has joined 2 months earlier. That is what they have admitted on so and so HR/ agency. He had opted for the post of lift khalasi. Thereafter, was also granted temporary status as lift khalasi, whereas SN Das continued to work as lift operator daily wage basis. Sri SN Das clearly has more experience working in the lift as lift operator than Sri Harichandra Das. Thus, SN Das stands to get the post of lift operator. Orders to that effect may be issued. Your Lords may kindly see only 2 paragraphs of their counter, only one line each. I take your Lordships to the counter filed by the state. Here, your Lords may straight away come to page 51.
Yes.
Page 51, your Lords got it.
Yes.
Page 51, para 6, your Lords may. Para 6. May I read, my?
Page 51.
Page 51. That is the counter affidavit filed by the central government.
Yes.
Page 6. This is the admission regarding the PT appellant. In reply to government so and so, it is humbly submitted that Sri Harichandra Das was engaged to operate the lift with effect from 1st of June 1990.
You are reading which?
My lord? Para 6.
Yes, please.
It is humbly submitted here that Sri Harichandra Das was engaged to operate the lift with effect from 1st June 1990 to 31st December 1999 under Bhubaneswar Electrical Division. Bhubaneswar Central Electrical Division, CPWD Bhubaneswar. You will pause here and then come to para 11. Next page, page 52, para 11. That is with regard to the admission, the admission with OP number 5.
Yes.
That it is humbly submitted that on the other hand, Sri Surendranath Das, OP number 5, was engaged to operate the lift on contract basis with effect from 1/8/1990 to 31st/8/1999. So he joined 2 months after to me. He was terminated or disengaged 4 months prior to me. But still, the authority hold that he has got more experience, though we were all continuing. And the intervening factual.
Little bit you forgot to read that the labor code directed.
Yes, that is what I was just starting. The intervening circumstances is after that 99 the issue came. I approached the tribunal claiming regularization, and that was the direction given in the first round of litigation of mine, which led to grant of temporary status in my favor. He challenged this disengagement of 1999 in the year 2001 before the industrial tribunal. Industrial tribunal directed the whole that disengagement as bad, directed him to take him back, and he was taken back into service 2 months after my regular appointment as lift khalasi. My lord, may kindly see, I was granted with temporary status as lift khalasi on the plea that no post of lift operator was existing. That was the plea taken. But after in implementation of the order of the industrial tribunal, he was taken back in service as lift operator in the month of August 2008. My lord, in the subject to correction, my lord.
When did you join as lift operator?
Well, I joined on 1/6/1990. That is what they have admitted. He joined on.
Just a minute.
First year. Wait.
1/6/1990.
He joined on 1/8/1990.
And you worked up to?
Well, I have been continuing all through.
No. Later you were working as lift khalasi.
Yes, but before that, I was continuing as lift operator from the 1/8/1990.
1/6.
Sorry, 1/6/1990 till 31st December 1999.
No, that has been corrected.
91.
91 in the counter. In the counter, that has been corrected to 91. Thereafter, there is some gap.
That is their certificate.
No. That was the first certificate given. I was continuing. That is not because.
Give the details, no?
Yes. My lord, yeah, I'll take your lordship with your lordship's permission. I'll take your lordship to the finding arrived by the
counter that
finding, but we are trying to understand the facts from you.
Yes, ma'am.
You are the best person to tell the facts.
Yes, ma'am. I continued till 99.
We put this question that you were engaged as lift operator.
Yes, ma'am.
On 1/6/1990.
Till 99. Till 31st December 1999.
Till 31st December 1999.
Yes.
What
So,
happened thereafter?
Thereafter, they allotted this operation of lift by way of contract. Again, I was the contractor. I took that work of lift from the authority. I managed to continue as a contractor from 1999.
So you were not a lift operator after 1999.
I was not lift operator. I was given to operate the lift on contract basis.
There is difference between contractor and operator.
Well, that is
contractor. When the contract is given to you, you can run that. You can do that, or you can ask someone else also.
No,
like
my lord, I am coming.
So you yourself have said you took it on contract.
Yes.
So you engaged. Okay.
No, my lord.
Okay.
Yes, my lord. My lord, what happened, my lord? They gave on contract to operate the lift both to me of one lift and to OP number 5 in another lift.
Okay. He also got a contract.
Yes. That is what the finding of labor tribunal.
When?
In 99.
99.
In 99.
Okay.
So
31/11/1999.
Yes.
Contract.
Yes. So that was the cause of action before the tribunal in the first round of litigation, where the tribunal gave a finding.
Just a minute. So after 1999,
yes,
both of you must have been removed.
Yes. That is that. Both of us were removed. I don't.
Both of you were removed, and the work was given to a contractor.
Yes.
You were the contractor.
Yes.
Now after that,
yes,
he files industrial dispute. He raises an industrial dispute.
Yes.
All right.
Yes.
In 1999.
99.
All right. So he
in 2001. In 2001.
All right. Wherever.
Contract was from when to when?
My lord?
Contract was from when to when?
There was no annual basis. there was no,
So 2000, from 2000.
Please appreciate, let us understand the difference between you and him.
Yes, yes.
He raises an industrial dispute
Yes.
against the termination.
Yes.
Contract, according to you, was given to him.
Yes.
What did you do in 1999?
Well, I approached the CAT.
When?
In the year 2001, that is the first round of litigation.
All right, forget first, yes, 2001 CAT.
Yes, ma'am.
You
Sorry, my lord, I stand myself corrected. I approached the tribunal for regularization in the year 2005.
2005.
I approached the tribunal in the year 2005.
Yes. So what did the tribunal do?
Yes, that is what your lordship, I am drawing your lordship's attention to Annexure 2, page 30.
Yes.
Page 30.
So what did the tribunal do?
Yes, the tribunal your lordship, that is what your lordship kindly see page 30. But why I went before the tribunal, that has been mentioned in para 1. Applicant was being engaged through a contractor discharging duty of lift operator in the income tax and central excise revenue building, Rajaswa Bihar, Bhubaneswar. It is his case that though he has been continuously discharging the duty of lift operator since 1/6/1990, neither he has been conferred with temporary status nor regularized, although the said benefit have been given to other similarly situated employees. Para 2 may be kindly seen. What was the stand of the Union of India there? Respondents in their counter have stated that applicant is not entitled to conferment of temporary status regularization in Group D post since he was engaged on contract basis for operation of lift operator, which is a Group C post. You lots may kindly see.
No, that is all right, but is that correct? How can a contractor be Group C?
Well, they have allowed, they have accepted that. Your lordship may kindly, so far as the respondents.
We understand, Mr.
Thereafter, your lordship may kindly see, it has been maintained that he has been awarded work on contract basis.
Oh.
He has been awarded the work on contract basis through contractor for operation of lift on income tax building, Bhubaneswar. Thereafter, in paragraph 6, it has been stated.
No, next line.
Yes, he can be said to be an employee. He cannot be, sorry, I stand myself corrected. He cannot be said to be an employee engaged by the respondent either on casual or ad hoc basis. In paragraph 6, it has been stated that prior to December 1999, work order was given to the applicant, and thereafter, since December 1999, tender has been awarded to somebody else. Thereafter, para 3. At Learned Counsel, the finding of the tribunal. From Annexure 1, it reveals that the applicant was engaged from 1/6/1990 to 31st December 1990 on a monthly remuneration of 1,000. From enclosure Annexure 2, it reveals that he has been working since 1/6/1990 to 31st/12/1999 on different spells covering the period of 6 months to 1 year in a particular year. It has been admitted by the respondent in their counter at paragraph 6 that the applicant was given the work order directly and not through contractor prior to December 1999. The period of engagement of the applicant is not in dispute, nor it is the case of the respondent that he was awarded work after floating the tender, etc., as has been done after December 1999. Thereafter, you lots make kindly see the 2 lines there. It is also specific case of the applicant that similarly placed employees have been given benefit of the scheme under Annexure A/2, whereas the applicant has been deprived of. This plea of the applicant has not been controverted by the respondent either in their counter or during oral hearing. Therefore, there is no hesitation to hold that the engagement of the applicant prior to December 1999 was on casual basis, and therefore he is entitled to the benefit of the scheme of the Government of India under Annexure A/2. This order of the tribunal attended finality, and they themselves have implemented the same under Annexure 3. So all under Annexure 3, by granting the coverage of temporary status in my favor with effect from 1993. Let me kindly also mark it. The benefit of temporary status was extended in my favor from 1993. And while conferring this status, all through they were taking the stand that I was the lift operator, I was operating the lift. suddenly they granted the temporary status in my favor, saying that you are granted temporary status as lift khalasi against a group D post. All through they were saying it is a group C post. I was working as group C, but here, my lord, while granting, they have granted me group D benefit.
When did they grant you?
On 12th of February 2008, Annexure 3, running page 16.
So did you challenge this?
No.
Accepted.
Facts are facts. I have not challenged. I have not challenged. And my lord, I challenged it only when the advertisement was made. And your lords may kindly see.
So you challenged the advertisement before participating in the selection or after?
My lord,
After he got selected.
See,
no.
In simple, Mr. Counsel, in simple words, the difference between you and him is that both of you were working since 1990 till 1999. The difference is that he questioned the correctness of his termination by raising an industrial dispute. That was allowed. And therefore, he was reinstated because his termination was held to be bad. In your case, you continued as a contractor, and thereafter you accepted your position as Group D post temporary status. So his experience, he continued throughout because his termination was held to be bad. That is the difference.
My lord, I'm not disputing that. That's a fact. I cannot dispute it. My lord, my entire endeavor is when there were two posts.
You made your best of the endeavors.
When there were two posts, they should have also advertised for two posts. But
Even then, my lord, even till today, they could have, my lord, even they could have, by allowing one post of lift operator to go vacant and not extending that benefit and extending the benefit to in favor of another to him.
He was smarter than you.
My lord?
He was smarter than you.
Yes, my lord. He's
All right.
I have to admit, my lord, he is smarter than me.
No, he because he chose a correct forum.
My lord,
Because and you accepted everything. Like when it was given to you on contract, you accepted that.
Yes.
In 1999, you continue as such till 2005.
Yes.
In 2005, you file an application before the administrative tribunal.
Yes.
Administrative tribunal, what the administrative tribunal has given, that we can see. And in his case, he approached the labor court. He raised industrial dispute.
Well, even the same plea, whatever was taken.
Maybe, but the difference between
Yes,
you
I
and him is that in his case, termination has been found to be illegal.
My lord,
in your case, there is no such finding.
Yes, my lord.
Difference.
Yes, my lord. That is the difference.
just out of curiosity, when did the tribunal pass the order?
My lord?
When did the tribunal pass the order
In my favor.
his favor?
In his favor, the order was passed. The order was passed on
2007.
2007. 2007.
Filed it when?
He filed it.
In 2001. 2001.
In 2001.
All right.
That is available at page 39.
Well, that is all. I was just wondering when
Yes, ma'am.
you filed the.
Yes, ma'am. That is
after he got the order or in between?
My lord?
No, I wanted to know whether he filed the way after he.
No, prior to that. So my lord, what has happened, my lord?
What has happened? No, what has happened?
Yes. My lord, now my entire issue here is once, despite the recommendation, your lords may, if your lordship permit, I will take your lordships to that recommendation made by the authority.
Not required.
Yes, ma'am.
No.
Yes. My entire endeavor before your lordships was that once it's a fresh advertisement, and both of us.
See, Mr. Counsel, had you conducted his case from the very beginning, the matter would have been different.
No, I had not.
Exactly, that is what we,
No.
we explore.
No, I am not. But so I was having this narrow compass
Right.
to be placed before your lordships. I have done my part of the
We are
duty.
very happy that you attempted to make out your point.
And only so your lordship, that was the point I want to make. If he is not eligible, naturally your lord, if he is not eligible in pursuance of the advertisement, then the entire selection goes. He is not eligible because his application was ineligible and subjected to have been rejected. Because of the law,
That ground is available.
so now your lordship is saying, because after participating, I have challenged, I cannot raise such a plea in view of the Katanab judgments.
Yes.
So
Therefore, your point is very limited. And
Yes.
your only point is that he had not submitted the certificate in support of his qualification.
Yes.
That will take into
Yes,
account.
that is what, my lord. I am only placing one judgment. No, I know what is your lordship's view now, my lord.
Give.
But still, my lord, I want to bring it to your lordship's notice.
Yes.
The judgment of State of Bihar versus Madhukund Ranjan. That is the and.
Yes, we will consider this.
Yes, and only thing, my lord, after all these things, my lord, I would only bring it to lordship's notice, if your lordship permits, subject to your lordship's permission. My lord, it's a fact, there are 2 sanctioned posts of lift operator, and one post is lying vacant, and I have been allowed to continue as a group, as a lift khalasi all these years, saying that you are temporary status, you cannot be considered. So in both ways, my lord, I am a loser.
Yes.
Yes, this is my case. If your lordship wants to get that document, see that document, I can place it regarding sanctions.
Not
Deeply obliged. My obliged. Deeply obliged.
Third, so and so. This is for judgment on after Thursday.
Okay.
Indeed, the problems.
Thursdays are which Thursday?
He's still here.
My lord, only with the lordship's permission, one fact. He is going to I knew he is going to retire in the month of February 2015 at 25. I am going to retire in the month of June 2025. That is the entire career of ours. Obliged.
Because my learned friend was not there, he is not well aware of the facts. He has already challenged that termination in tribunal and for regulation. That was dismissed in 2001. That is 557 of 1999. I approached the industrial tribunal. He approached the central administrative. And that case was dismissed.
Rightly said, I was not the counsel, so that was not with me.
I have mentioned in my counter.
Okay.
That was not challenged there.
Dismissed on 10/2/2001.
Yes.
Just give us a date chart.
Only in one my para, it has everything has been mentioned.
Yes,
Yes, I'll
give
give.
us a date chart.
Obliged. Okay.
No, but you can do it by Monday,
By Tuesday.
Tuesday. Date chart is nothing.
And in the before the learned tribunal, only advertisement was challenged. Neither my selection process or my appointment. That I will give.
Yes.
Item number 3.
I am for the opposite party number 5 in this matter. And the petitioner had approved praying a refreshment of the loan account. In the meantime, 10 years has been passed. And
So become infructuous.
ma-
So no instructions or infructuous?
infructuous, ma'am.
No, he's the other side.
Please appear, you're for the respondent.
I am for the opposite.
Your name, please.
Sheikh Aziz.
Take
Aziz.
on behalf of Mr. N.K.
N.K. Das.
There is no representation on behalf of the petitioner. Mr. So and so appears on behalf of opposite party number,
Party number?
5.
contesting opposite party number 5. So it seems, considering the nature of relief sought for in the present writ application, that the writ application has lost its purpose during the pendency of, during its pendency. Stop. The writ petition, its application is accordingly dismissed. The prayer लिख देना, prayer type कर देना.
Item number
Following
4.
of the prayer, following of the prayer made in the seems.
Item number 4, I need some time to take instruction because the son of the petitioner, he's been diagnosed as he's suffering from cancer and he's gone to Mumbai now. I have to get some instruction in this matter. Okay, let's may call it after holidays so that the eldest son, he died, but cancerous.
All right.
The younger son is suffering and he's not in a
As
mental
requested
state.
on behalf
Yes,
of the
absolutely.
TS application, I appear for the corporation, madam. TS application
That has been
for
rejected.
2011, that was rejected on the allegation of malfeasance. So my learned senior has challenged that rejection order. So my lord,
What is the development within the state? Yes.
regent status of the
I think the matter is being listed after 11 years.
after 11 years. Exactly, my lord. That is. I also need some instruction.
On behalf of the petitioner, list this matter on parties. List this matter on
24th.
next 24th.
24th.
24th October.
Item number 5.
It may kindly part 1, my lord.
Why, sir?
Madam was
I am on way from the
This case,
attending another case.
in this case, noting that, my lord, I have not served the copy and additional affidavit. I am serving in, my lord.
have you received the counter affidavit?
No, my lord, I am serving, notice.
Then another affidavit also.
No, I am also serving that affidavit, both the counter affidavit and affidavit.
Filed.
My lord, it was filed on.
You are waiting for appointment as notary.
My lord, appointment of notary this.
Yes. Every day, we are interacting with our teacher and we are telling them that we treat that this was a word matter. We are
Only one. Only one.
what? You want to become grumpy?
Or is it the same? What have you stated in your counter? Have you gone?
Only in the counter it was stated that earlier he had appeared before the committee twice, and the committee had not considered as not suitable for the.
As insisted on behalf of the city. It's a long granted. Government is better. It is unfortunate that after has been pending for more than 7 years, relating to appointment, relating to inform and negotiate to be appointed as notary.
Not really is that.
Active.
And please, are you serving, what is your?
I am serving the copy now. Counter affidavit and also the affidavit. I am serving him copy. Counter affidavit and as well as affidavit.
No, no, the council, the council.
Like.
Please take. Sir.
Well, I have already served.
Item number 6.
Sir. Item 6 was mentioned.
Mr. Manti, actually also has done that.
44.
Item 7.
Item 7 matters. Land. My land matters for the purpose of laying railway line matters was acquired. I am the matters affected person. My land was acquired.
Foundation trust.
Trust. The trust is the owner of that property. It's kind of a glance to Annex 1, page 8. This is voluntary organization matters. This is the is a trust and it is the owner.
People's Forum Foundation Trust.
Yes. It has purchased the property and it is the owner of the property.
Where is that?
Next on page 8 matters. The notification is also in my name. It's kind.
Well, kindly have a glance to page 1, 2,
12.
12.
Your name is there.
Yes, with 1, 2, my plots, my plot serial number 9. That's no payment compensation. That is, we purchased minors we purchased it in the year 2008 minors. That I have not mentioned, my lords, but fact remains there is a notification and notification covers it. There is no dispute about that acquisition of that land, and notification I have referred to in Annex 2.
Page 12. that
Page
is
12.
Part of that
Yes,
notification.
part of that notification.
That land has been acquired.
Land have been acquired and that has been possession has been taken over. Rail line have been laid. Two contingencies, minors. One, what happened? The front portion abutting the road, it was taken over. Minors, because of the acquisition. The rest portion became minors unused, and this so far that this portion have not received the compensation. Notification was made, minors, in the year that is in 2012. 2012. Minors.
And when was the acquisition over?
Consequently, immediately, minors, it is a urgent acquisition.
Acquisitions.
No, minors. One
That's for paragraph 2, it appears there are 2 acquisitions.
acquisition of 2 plots.
Yes.
No, acquisition of 2 plots.
For some part.
Yes, part plot. So rest of the plot, my lords, it remained outside because these are all residential. Of course, but I have no access to that plot now. What happened, my lords? Suppose, my lords, a big size plot is there, front side has been acquired, the rest portion of the plot, I don't have an access. Now, first portion of the line is laid. Rail line is laid, my lords, in front portion. So there is no access now to enter into the rest portion of the plot. My humble content is twofold. So far, that portion, whatever you acquired, kindly pay me the compensation. The second portion will become unused. That is what, my lords, I may be also, that may be taken over and I may be. That consequences will follow, my lords. Once they pay me the compensation, I will dispute it and then I will carve out my remedy. Thing is that, my lords, I may pray.
You have implemented state.
The state is the acquisition authority is the state. On behalf of the railway, for the purpose of railway, that is Khurda Balangir railway lane.
Yes, sir. That notice notes, I will take instruction in the matter. But here, what he is saying, he had the scope to raise all these objections as per the National Highways Execution Act. Section
National
3.
Highway, it is not National Highway.
I mean, sir, Railways Act. He could have raised objection with regard to that acquisition, saying that all the lands left out will be.
That part is there. That I will take care of. So far, that payment in the
whether you have raised an objection or not.
That I will carve out. Once I get it, so far enhancement of compensation.
I'm not saying enhancement. I'm saying that he is saying that the rest of the plot, which is not acquired, he could have raised the objection. These will become useless. So kindly also acquire this.
Minutes. Minutes. That is at phase 10, starts from phase 10.
5/9/2012 is the notification.
That is in vernacular Odia, minutes. If else will permit me, I will translate it. Minutes, I'll give it. I will translate.
Most surprising aspect is that this application was filed in 2013.
Yes.
And for the first time, this matter has been taken up. After it was taken up earlier, and when the report had seen certain defects.
Defects.
Notice 2013 and thereafter.
Whether that trust is still trustworthy or not.
No, my lord, that for the East Coast Railway is there. Trust one.
Your trust.
Not trust is one.
No, how do you know? Because the matter has suddenly been listed today.
Yes, no, so far that present trust, that is a trust listed on the Trust Act. That part, my lord, what my lord says, my lord, is correct because I tried to contact over phone today and even yesterday also. That phone number that is switched off, is found switched off. So that also, that part, man, shall take instruction. Instruction, man, I'm trying because this is an old matter. I'm to contact him and I'm trying, but the whatever phone number I noted, I tried to contact over that. But in fact, when it's this is found switched off.
Hope they have not given that same address where you cannot access that land.
We have already.
That you were directed
Minute.
to file an affidavit.
Minutes.
By an order dated 13/2/2024.
Minutes.
That you have not
Received.
done. And you cannot see this application. But you can application of second on 13/2/2024. And following order was found. We are appealing. No, affidavit has been filed in compliance of the said order dated 13/2/2024. Since in such view of the matter, since the application is not supported by the affidavit, as we required under Rule 3 of Chapter 6 of Part 2 of the Rules of the High Court of Orissa, 1948, the said application cannot be entertained and is prohibited. Why has it come before division bench?
Because it's under the Orissa States Abolition Act, we act, that's why it's before lawsuit.
That day we were searching for.
That is case is posted to Monday, will also lawsuit, with regard to that roster. As per rules, how the success have been given to different rosters, OSS under this honorable single bench, OEA, OGLS honorable division bench, like this.
What is the dispute about?
This is regarding settlement of a land, the claim under the OEA Act, so also OSS Act, not so various
Revision is challenged.
challenge. So I would also request a lot to give me some time because I rely upon two decisions of the Honorable Supreme Court, also full bench judgment of Patna High Court. That is 1964 Patna full bench page 1, where relying upon the which has been passed, relying on the 1955 Supreme Court, wherein there is a bar under the Orissa Communal Forest and Private Land Prohibition Act 1 of 1948, where it says that any lease has to be registered. Here, I think there is no registration. Some points are involved, Lordship, you have to hear this
I
matter.
was jointly requested on behalf of the parties.
Citation.
Beforehand, I will give those items.
This matter on 24th. Mr. Samantrayal and AGA has submitted that in view of Supreme Court's decisions and a full bench decision of this has relied on Supreme Court's decision. Do you have the citations?
Yes, I have citation of that Patna full bench, but 1955 Supreme Court, I could not get the page number, but it's 1955 Supreme Court.
And a full bench
Partition name is there. I will give it.
To oppose the chairman in the writ petition. First off, let the citations be supplied by him. Citations of such decisions be supplied by him. Lists him in the meanwhile. Yes. This was 24th. Okay.
Item number 9.
That's why I'm appealing for the OP number 1. Previous council expired today.
I am appealing for the petition. Now the sole petition expired since long. Therefore, I have no instruction in this.
No instructions.
Okay, please.
For the OSFC.
Yes.
Item number 10.
Item 10, my lord. 10, my lord, after vacation, because I have not taken any instruction.
You don't have any
So
instructions.
here, my lord, the prayer is the differential salary from 1988 to December 2011. Is a lower judicial employee. He has retired in the meantime, and the counter has been filed that amount has been sanctioned. I have to take instruction whether he has received the same or not. And apart from that, my lord, the grade pay perhaps has not been properly fixed. That is the and also his prayer is that his promotion be considered from the date when the post was lying vacant. He was given promotion in the year 2011, but prior to that, the post of senior clerk was lying vacant. He was not given promotion despite his several approaches. That in the meantime, he has retired, and I have no contact, so I will only prayer after on 24th, so that I can take instruction.
This shows that his grievances were addressed. Yes, he did not contact you. In view of the counter affidavit, we may dispose of, and we'll give you liberty to raise your grievance before.
Or your lords may give it liberty to approach the opposite party number 1, Lord District Judge. So he will look after the.
In case any cause of action is available.
Yes.
The third learned counsel for the party. This writ application has been filed seeking following reliefs. First off, the writ application was filed in 2013. the petitioner has retired in the meanwhile, comma, during the pendency of this writ petition. So a counter affidavit has been filed, from which it appears that the petitioner was, from the pleadings on record, it appears that the petitioner was appointed as junior clerk on ad hoc / temporary basis, initially for a period of, this is on 21/7/1988 by opposite party number 1, initially for a period of 89 days, which was subsequently continued till subsequently extended, and thus he extended from time to time, and thus he continued up to the month of April 1989. Later, in the light of an order passed by this court, he was appointed as, on the judicial side, he was appointed as, service of the petitioner was regularized, and he is joined as such on 22/10/1990. So stop. Next, from the counter affidavit, it appears that the pay of the petitioner was revised and refixed at the stage of 7,700 in the corresponding pay band 5,200 hyphen 20,200 with grade pay of 2,000 with effect from 1/1/2006, with the next dates of increment as mentioned in paragraph 5 of the counter affidavit. Also, it has also been stated in the counter affidavit that a counter affidavit in relation to the petitioner's claim for grant of promotion, that the petitioner's case was considered for grant of promotion, and it was in that process it was noticed that the CCRs for the period 16/11/2002, 8/4/2008 had not been entered in his service book, and for the period 9/4/2008 to 21/7/2008, there were adverse entries. Stop. The petitioner himself had made a representation before the district judge that because of his deteriorating health, he was unable to perform his duties smoothly. As smoothly, this said representation was filed on 5/5/2011. The petitioner, at that point of time, the petitioner was going to retire in the year 2014. First off, this is the background in which, the petitioner was denied. The petitioner was not considered fit for promotion. So, next. Be that as it may, considering the stand taken in the counter affidavit, we are of the view that since the petitioner's grievance has been substantially redressed during the redressed, this application can be disposed of with an observation that the petitioner shall be at liberty to approach opposite party number 1 for his pending grievances, for remaining grievances, if any, can an approach. Number 1, pointing out his grievances headwise. Stop. It is expected that the district judge shall duly consider such grievances and redress them in accordance with law.
My lord, my presence for opposite party number 3, 5 and 7 may kindly be noted.
Yes, 3, 5 and 7.
Raise submission item 11.
Phone number 11, may I please, my lord, say, I am filed the present writ appeal, my lord, accepting the order under annexure 1, part 5, the honorable single judge, ma'am. Wherein, my lord, the honorable single judge has directed to start the eviction proceeding in respect of the present petitioner, my lord, and to stop the construction of the building, my lord. Without hearing me.
Where is the order?
Order under annexure 1, page 13, your lordship. Running page is as page 14, your lordship. May I read to lordship?
Yes. So what is the order?
Order is page 14, your lordship. Paragraph 5, my lord. 6, your lord. In view of the above submission, my lord, this court directs the opposite party number 2, that is Tahsildar Bhadra, to ensure the vacation of the land in question by the opposite party number 4, and also stop construction activity, if any, forthwith, my lord. My humble submission that I am a party to the present writ petition, my lord, but without issuing notice, my lord, and without hearing, my lord, the order has been passed ex parte, my lord. And humble sir, the fact remains that basing upon some allegation of some villagers, my lord, the representation was filed, encroachment was proceeding was initiated against me, my lord. Under annexure, lordship, I have filed, my lord, and annexure forced, my lord. And after receiving the encroachment proceeding notice, your lordship, I have filed my so cause, my lord, stating that let a demarcation may be made if I found that I have encroached upon the government land, my lord. I will so moto demolish my land, my lord. But without suppressing the fact, my lord, the writ petition was filed and the order was passed, my lord.
The present intra-court appeal has been filed, sealing an order dated 28/8/2024, passed by a learned single judge of this court in WPC number 9699 of 2024, whereby the Tahsildar Bhadrak has been directed to ensure eviction of the appellant from a plot of land having description plot number 522 Kisam Gochar and plot number 333 Kisam. No, 4 is all right. Kisam Gramya Jungle under Khata number 204 of Moja Khanbadi in the district of Bhadra. Stop. Next, learned counsel appearing on behalf of the appellant has submitted that the said order against the appellant has been passed without issuance of notice. Postopsy has also submitted that
Encroachment proceeding is initiated, my lord.
that an encroachment proceeding has already been initiated in which the appellant is participating. Postopsy contends that the appellant himself has made an application for demarcation of the land and given an undertaking before whom?
Before the Tahsildar Bhadrak.
Before the Tahsildar, that any area of the if any area of the land was found under unauthorized occupation, he shall vacate the same. Stop. Next. Yes.
No, sir. I would
Issue
say also-
notice.
I don't have a copy.
Issue notice. Stop. In the meanwhile, the operation of the order dated 28/8/2024 shall remain stayed. Stop. We make it clear that the order of stay shall not in any manner affect the encroachment proceeding. What is that case?
Well, encroachment proceeding number 544 of 2024.
Yes. 544 of 2023-24.
And shall continue without being prejudiced by the present interim order.
Mr. Copy be served upon
Let
me.
a copy of the writ appeal be served on Mr. L. Samantrel and AGA.
My lord, may I submit one thing?
Accept notice.
After filing the present writ appeal, my lord.
Issue notice. Issue notice. So he accepts notice. Yes,
After
madam.
filing of the present appeal, my lord, one notice was fixed on the wall of the petitioner, my lord, directing to demolish the
All
construction.
right, so this is the order now.
My lord. That
No, once that order is.
Speak.
Stayed.
We have stayed the order.
Must be fixed date after the holidays. I can file the counter and details in the meantime, my lord.
Yes, 1 week, 6 weeks.
My friend
4
will
weeks.
serve a copy by Monday, my lord.
By Monday, I will serve it.
Requisites 1 week. Requisites 1 week.
Requisites for the private parties, not to
5 to 7.
Six weeks.
25th, 4 weeks. 25th, 11th. And
25 November.
25th.
Item 12.
May I please, Lordship? In this matter, your Lordship, my limited grievance before your Lordship that in spite of completion of the work in all manner, completion certificate has not been issued till date. And so far as the completion is concerned, your Lordship, at page 56, your Lordship, they have admitted that in all respect, I have completed the work. Page 56, Your Lordship.
Yes, what is the system?
And as per judicial.
I'll take instruction, my lord.
So what else is completion certificate? Just
At
matter
page
of-
24.
Let's this matter, so accept notice. Let's this matter on. um, not- 20. No, it's not whole matter. 27th.
My lord.
Within first 5 cases. So if someone has completed. the
My lord,
work,
I'll
then
take
why should
instruction,
you
my
not
my lord.
stop the limited grievance which the petitioner has in the present writ application is that despite completion of the work awarded to it, comma, the competent authority is not issuing the completion certificate. Or stop. If there is no impediment, comma, the court expects that the competent authority shall issue completion certificate.
My lord.
27? Oh, 28.
28. My lord.
Item 13. Please, Your Lordship. Lord, advocate for my lord, Your Lordship, kindly come to the page 4 of my petition. The common cause, and the court has directed apex court, as per apex court direction, I need to compute the amount has to be, compensation amount has to be paid. Annex 1, they issued notice. I could not pay. Revision I have filed. Revision that was disposed
item
of.
is
Revision was disposed of, Annex 10, and I came to High Court. The direction was there, 15 days I will deposit. Thereafter, therefore, I have deposited prior to that, and thereafter, last order, page 73, the lordship kindly see.
Just a
Annex 16, page 73.
please wait. Yes, what is your prayer? Section 10,
Yes, sir.
you are challenging this.
My lord, I have paid the complete compensation as has been directed. And that OPDR proceeding has been initiated, and as per the Supreme Court order that I have quoted the relevant portion, page 4.
No, are you challenging this order, Section 10?
Well, Annex 10, my lord, I have challenged, and Annex 11, court has disposed of the case. Court has disposed of the case, court has directed, page 59, your lordship kindly see. Page 59.
What do you want now?
No, my lord, I have paid the compensation, notice has been issued, also order has been issued, instruction has been issued, director mines, page 73, that I have paid the complete amount of compensation. Fully payment, I have compensation demand in respect of the mines. DC now requested the director with to withdraw the lapse proceeding determination proceeding for obtaining requisite statutory.
No, but who has recommended? Somebody has recommended your case for
No, my lord, I have already complied the order of court.
Supreme Court has passed the order. They just said then even
That I have
the
complied.
termination order will be revoked. What is the order of the Supreme Court?
Supreme Court, my lord, after payment of compensation, the mine holder
Where is
can.
that? Where is that?
Page 4, your lordship.
Page 4 of your writ
Page 4
petition.
of my writ petition, I have quoted the paragraph.
There's a piece of deposit fines. That had granted it. I'm saying that there is further order is granted that the revenue can be revoked after entering. So you say that we have paid as per the order of the Supreme Court, termination of 9 days will be revoked.
Yes.
Can restart the mining operations, all right. But a particular time must have been fixed. It can't be that you will go on forever.
No, time was there. Time was there.
2017.
So 17. Thereafter, I have filed revision because they have statutory period last and they have issued notice annexure 1, 21.5. They have issued notice. That was only challenge.
No, he did not deposit. Lessee did not deposit
not
the amount
deposit.
within time.
I did not.
And thereafter, in the common cause case, Supreme Court directed to initiate OPD Act also to terminate the lease.
No,
In view of that common cause case order, the lease was terminated.
No,
No, he's saying relying on this paragraph 227.
Well,
But that 227 paragraph, they've directed on or before 31st December 2017.
my lord.
That's the problem.
No, even if, my lord, that is revision lies in 31B, my lord, even if inaction of the state government. So let him approach the revisional authority. Your Honor can see 30B of the MMDR Act. A and B both, my lords.
Yes. 30.
30B, my lord. 30A and B both, my lord. Power of revision of central government.
Yes, do it.
Section. After the show cause notice was issued, section 30 I had filed revision. That was both the revisions that was disposed of annexure 10. Thereafter, I came to High Court. High Court directed to deposit it within 15 days or interest. By that time, I have already deposited the amount. Thereafter, they simultaneously they have terminated and they have initiated the OPDR proceeding. OPDR proceeding, they have put director has requested that it should be drawn. So now question remains only termination when it
So
is
there is an order of termination.
Termination when it annexure 5.
There is an order of termination.
Yes.
So you are challenging that order of termination.
Yes.
You can challenge, invoke this for
pass.
And counsel for the petitioner after the argument seeks permission to withdraw the said application with the liberty to invoke section 30 bracketed 30 of the MMDR Act by making revision application before the central government against the impugned order of what is the impugned order annexure?
Annexure 5.
Annexure 5, my lord. In fact, he is challenging
Annexure
that proceeding.
Annexure 5.
At first 34.
Proceeding is still pending.
Proceeding disposed of. Revisional proceeding, both the proceeding disposed.
Revisional proceeding disposed of.
Revisional proceeding disposed.
Revision he has filed challenging the termination that has been dismissed.
My lord?
That has been dismissed.
That's because he has not deposited that amount, that illegal mining.
Order.
Revisional order he has not included.
Annexure 5.
Annexure 5 the proceeding.
No, annexure 8.
Fine, common order is
Annexure 8.
My lord.
Rejected, my lord, annexure 10, page 52.
Sorry.
52 and 53.
Why are you showing us annexure 5? How can you challenge annexure 5?
This is common order that has been disposed of annexure 10.
Considering the review where the appearance has no substance.
Thereafter, I came to this High Court before your lords.
No, what is the fresh cause of action?
The cause of action, my lord,
See, after this order of 22 was passed, You approached this court
My lord.
and thereafter that order was passed. Let us have the dates, clear dates. Against which order he should approach the authority?
Well, even if the
Again,
against the
revision.
inaction, he can also file a revision, my lord.
All right, let us see.
My lord, lordship can see 30A and B both.
11/3/2022 order was passed under section 3 inter 30.
Section 30.
This 11/3/2022 order was passed under section 30 by the central government.
By the central government.
Yes.
You say yes or no?
Yes.
Yes. Thereafter, what happened? What do you do again?
Thereafter, for depositing the money for extent for some time, I have undertaken as per affidavit. Court has passed the order. High Court order, Your Lordship, I have enclosed Annexure 11. Your Lordship, kindly see. Annexure 11, page 59.
The petition says that you had filed only for extension of time.
I have filed. I have filed extension of time to deposit the amount.
10.
Annexure 10.
Division has dismissed stating that you have filed the revision only with the, intention.
Give some time, I will deposit
extension
the
of
amount.
time. That means the termination you have not challenged.
Lordship can see page 53, my lord. Revisional authority directed time up to 28/2/2022, my lord, for deposit that amount. Thereafter, he filed the writ application for extension. He is not challenging the order itself.
No.
And the revisional order also says that he has approached only for extension of
My
time.
lord, my lord, my lord. He is not, even till today,
Final
he is
revisional.
not challenging that order.
My lord,
Proceeding that order.
My lord, in revisional court, so cause was filed first. So cause notice. So cause notice was challenged.
Just
My
a
lord,
minute. Just a
I'll be
counsel.
grateful, my lord. Your Lordship can.
Just a minute. This 11/3/2022 order was passed under section 30.
Yes.
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 What is the order?
This is the first case 2295/2018 that was challenging the so cause. Revision was filed against the so cause. Extension of time. Second one was filed challenging the termination order.
Where is that?
Whether that, have you annexed?
Yes.
Sure.
Annexure 5.
We are asking whether any order has been passed by the tribunal regarding your challenge to the termination.
Both the proceedings were disposed of by Annexure 10.
There's nothing regarding termination, that you were challenging the termination, any contention regarding termination. Because, okay, you challenge that order of the tribunal in this High Court.
The termination here in the second revision, both were disposed of.
So you
Here also I have filed
So you
extension and
So you
termination.
filed one writ petition or two?
One writ petition.
So you challenge both.
Challenge both.
Look at the order. Look at the order of this court.
High Court is order is page 56 onward. There is order dated 19.
Oh, so both the orders you have challenged here. Now see.
Since common order was passed, by which
The High Court. So High Court has only directed you to pay the amount.
To
You
pay
had-
the amount,
you had-
High Court has only directed to pay the
Yes,
amount
and
and
you had
termination.
approved the
Termination,
Court, and this writ application issue direction to you. That's all.
to pay the amount.
That's all. That is the direction. And that's over, no further.
so my lord,
Now what do you want?
now my lord, I have paid since compensation amount, complete compensation with interest I have paid
See.
already.
We are the petitioner.
Have you made any prayer to them for revocation of the termination?
No. Yes, he is every because.
Mean original request.
Is pending.
No proceeding is pending now.
Then no proceeding is pending, everything has concluded.
That's
And
it.
everything has concluded with the passing of the order by the High Court.
Since I have already paid the compensation, I have prayed that this termination should be revoked.
All right.
That is what I have.
Who will leave?
Yeah, the-
It should be removed. Nothing can be done except dismissal of the writ petition on merits.
I will file challenging the termination.
What you can challenge?
Termination, actually, termination, well, the section they have invoked, that is actually not permissible under the law. Section 12, proceeding 1210, they have initiated.
Already challenged. That's the problem. You had already challenged the termination order. Have you passed a fresh termination order?
No.
That is the problem. That is, we are saying, how can we entertain this prayer now? Since you had already challenged the termination order, how can we find another writ doing that unless you approach them?
All right, whatever submission you are making before us, whether those were available for you to make before the division bench or not.
Yes.
Available, my lord.
That I will file a revision.
Available before the revisional authority.
I will file revision.
We will not observe that you will file revision or whatever.
Revision challenging what? Or inaction you are saying?
Inaction also the proceeding itself because the revision because the revisional authority has not considered the proceeding. Revisional authority simply said that as because you have not deposited the amount pursuant to order of the Honorable Apex Court. That's why we are not interfering.
But that part also clear by the Annexure 16.
I say that I will.
He submitted the same and the director Mines has passed an order. See page 73, last paragraph.
You may approach. We will not say, but we will not object.
Yes, yes. But you are not
Be
making
clear.
a submission. But on page 73, there is a prayer. After fully payment of the compensation demand, lessee has now requested to the directorate to withdraw the lapsing.
Yes.
So that.
This is not the lapsing, my lord. This is not the lapsing. This is the termination.
Remember,
My lord.
some remedy has, he can.
My lord, he can approach the revisional authority.
The 73.
Say that the court is
Why don't you?
Dismissed. Waiting. Yes, next.
Item
14.
I am permit to withdraw.
Liberty.
All right.
Liberty.
Council for the.
I am permitted to withdraw.
To withdraw this application. Stop. The
Liberty.
petitioners have.
Approach
Yeah.
the.
I will
appropriate
approve.
forum.
Liberty.
I will approve the appropriate forum.
Liberty to raise issue before appropriate forum if the same is legally available to him.
We are the pin number 1, let's say appearance will be noted.
Or
Item number 14. Item 14.
Is he there? You appearing? Is he appearing or is your associate?
No.
13
was. I was in
No,
13.
Item 14.
WC number 23269 of 2024.
Yeah.
Yeah. Regarding the appointment of Lokayukt and members of that Lokayukt members.
Challenging or wanting appointment?
Praying for appointment, but not following the rules of the, so is High Court PIL rules.
Has a defect been shown?
Take instructions. Yes. Notice. Eight weeks.
Item 15.
May it please, your lordships. My lords, initially I had filed a writ application challenging a tender call notice, my lords. That is annexure 6, whereby, my lords, I'll just explain.
Yes.
I was allotted, if your lordship kindly turns to page 24, by annexure 2, I emerged successful as a tenderer for tender call notice for empanelment of medicine stores regarding supply of drugs, consumables, and other items to Bhima Bhoi Medical College and Hospital, Balangir for the year 23-24. Now, your lordships may kindly see annexure 3, that is at running page 31. Here I have been called upon to execute an agreement for 1 year. Lordship may kindly see, inviting a reference to the above cited subject. This is to inform you that MS Panda Medical Store has been selected as the L1 tender for empanelment of medicine stores for supply of drugs, consumables and other items to Bhima Bhoi Medical College and Hospital, Balangir for a period of 1 year from the date of agreement with agency by the undersigned. Now, my lords, I execute the agreement by annexure 4 at running page 32, 4th day of March 24, and shall remain valid for a period of 1 year from the date of execution, from the date of this execution. So, my lords, 3rd March 25, this agreement remains valid, my lords. Now, this, if your lordship, as I have shown to your lordships, that the empanelment included supply of drugs, consumables, and other items. Other items includes the orthopedic implants. which they are taking from me as will be evidenced from Annexure 5
No,
series.
taking is different thing.
My lord.
What was the agreement? Whether from agreement you can demonstrate
My lord.
that you were required to supply.
My lords, from the agreement, it referred to, my lords, referred to drugs, consumables, and other items. Other items have not been specified.
Anything in the world.
No, my lords. I'll just point out before your lordships. This Annexure 5 series, they took all the orthopedic implants from my shop. My
That
lords.
is different.
My lord.
The question is of agreement.
My lord, the agreement other than, my lords, I am just harping on the word other items.
Yes, so other items we will have to define if we want us.
My lord, thereafter, your lords inquired as to on what are you being paid for these items and what is the mode of payment. Then we gave your lordships the earlier writ application. Your lordships had posed this question.
We are dealing with the activities of the state.
Yes, sir.
If the state says drugs, consumables, and other items,
My lord.
and in view of that agreement, you were meant to supply certain expensive equipments also, it's a different, they did it. But whether that will come under other items or not, in accordance with the agreement, is a question which we shall decide.
My lords, the very action shows that it will
will
come
not
within
extend
the...
action. Therefore, we said that we are testing the action of the state under Article 12.
No, thereafter, my lords, I gave the receipts by which they have accepted all my all the your lordship sees Annexure 6 series. My lord.
There can be a situation where we may have to hold that all such supplies were intention of the agreement.
My lord, there can be such a situation, my lords. But here, my lords, this other consumable
Let us see what items were supplied.
Your lordships will see Annexure 6 series, bipolar, penetrated, Schnall screw. These are all orthopedic implants. Schnall screw.
Where is the agreement?
Agreement is at page 32, Annexure 4. Your lordships will see terms and conditions at running page 33. The heading is, starting from page 32, the medicine store, second party has to supply all medicines, medical consumables, and other items to DHH, BBMC, and H, Balangir at the rate of 7% profit of purchase price of that item. Thereafter, your lordships will see, in case of any medicine, medical consumables, and other items, the treating physician may make a requisition to the empaneled stores for making available the medicine.
So what is your problem now?
My lords, thereafter after we filed this writ application, they withdrew the tender, earlier tender. Because they withdrew the tender, no cause of action subsisted for us. So we also withdrew the writ application. Now again, they have come up with a similar tender, my lords, which we are challenging before your lordship.
Difficult.
Because they will have to explain to your lordship whether this is not included in other items.
No, we can explain that. We can explain. Suppose tomorrow, if they have some radiology department, then you may say that the entire equipment should be supplied by you. It's 100 crores thing.
No, well,
why not?
These are all consumable items.
Consumable? What consumable?
My lords, other items which include orthopedic items, my lords, that is what that is why they have been taking from us.
You can participate.
This is specifically for orthopedic implants.
Lordship, kindly see page 24, my lord.
Orthopedic implants.
Lordship, kindly see page 24, my lord. The early tender document, my lord, for a moment. Annexure 2, my lord. 24. Tender call notice for empanelment of medicine stores regarding supply of drugs, consumables, and other items to Bhimabhoi Medical College Hospital, Bolangir for the year 2023-24. And Lordship kindly see the new tender at page 15, my lord. Tender call notice for supply of orthopedic implements set as per demand to Bhimabhoi Medical College DHA Bolangir for the year 2024-25.
My agreement is valid till 25 months. That is my case. 4th day of March 24 and shall remain valid for a period of 1 year from the date of execution of this agreement.
So unless it is cancelled, you will, according to that, what is the, which year have they stated in?
My lord, the earlier is for the year 2023-24. New tender is for the 2024-25. Annexure 1. Let's see, kindly see page 15 for a moment.
Agreement is valid.
Agreement for supply of drugs, consumable and other items, my lord, for a period of 1 year. And that tender was floated for the year 2023-24. And the new tender is for the 2024-25. And with the different context, my lord, orthopedics implements.
Yes, that I agree, my lords. Orthopedic implants, my lords, page 32, while letter number 588, whereas the last paragraph, while letter number 588 dated 2/2/24, Superintendent BBMC and H. Bolangir, the executor of second party who has been selected through a tender process, tender reference number 89, dated.
Where is your agreement? Let us see again.
Agreement is page 32, my lord.
Page 32. This agreement is pursuant to the tender under Annexure 2 months. 4/1/24.
Where is which annexure?
Annexure 4 is in pursuance of Annexure 2. Last paragraph also indicates. Dated 4/1/24, instructed to sign the MOU with the executant of first party. And I've placed that it shall remain valid for a period of 1 year from the date of execution of this agreement.
No, where is that?
My lords, page 32, right at the beginning, this MOU is executed today on 4th day of March 24 and shall remain valid for a period of 1 year from the date of execution.
Also class 16 of that time.
Page 32.
Page 32, my lords, Annexure 4. Between superintendent and the present petition.
Oh, there.
May make a declaration.
No one appears. Monday.
Item 17.
May it please your lordship. My lord, item 17, I am in history, your lordship. My lord, may it please your lordship.
Yes.
My lord. My lord, item 17, your lordship, the petitioner challenges the order under annexure 4, that is 5/8/2024 at page 24, whereby the petitioner has been my lord, whereby the petitioner has been debarred from participating in the tender process of Odisha Police for a period of 2 years, your lordship, wherein the petitioner has absolutely no fault, my lord. The allegation
No
by
question
the
of fault. No question of fault. Let me see let us see the operative
order.
part. What is that?
That is annexure 4, page 24. If your lordship will permit, I'll place just briefly the facts what they have stated.
It's the Odisha police.
My lord.
Yes.
My lord. What has happened, your lordship? What they are alleging that my lord.
Yes.
What they are alleging, your lordship, that I have to deposit EPBS, that is E-Performance Bank Guarantee. It is E-Bank Guarantee, your lordship, for getting these 5 orders. Now I have supplied it. They have paid me money. No obstruction in the work. No, nothing has been no hampering. Nothing. Now the question is that, your lordship, they say that is EPBGs, the bank guarantees I have supplied. These were not uploaded in NESL portal. That NESL, your lordship, is a central government portal, your lordship, whereby all the securities of the different government organs were kept and they can verify it from that. Now, your lordship, may kindly say annexure 3, page 23. Now, this EPBS system was introduced in 2021 February. So the bankers
We will not go into the merits.
My lord, I am not on merit, your lordship. My lord, annexure 3, page 23, your lordship, may kindly see. This will clarify everything, my lord. Annexure 3, page 23.
Yes.
Now, in annexure 3, page, before asking me even a show cause, they have asked an inquiry report from the concerned bank. It is Indian Overseas Bank. Your lordship, may kindly see. The bank has given a reply to them under annexure 3, page 23. I am just reading, your lordship. It is very true. Only 4 or 5 lines they have stated whatever they have done. I'm only reading it, your lordship. In annexure 3, page 23, the bank has given the reply to the police, the Department of Police, your lordship. Sir, madam, I'm reading it from here, your lordship. Refer to your above memo. Please note that all the 5 EPBGs, that is Electronic Performance Bank Guarantees, all the 5 EPBGs for GEM, that is Government E-Marketplace. In Government E-Marketplace, all these tenders, your lordship, they are now floating. It is a common marketplace for all the departments. The bank is saying that refer to your above mentioned memo. Please note that all EPBGs for GEM contracts were issued by our bank and are original. Initially, in place of mentioning client's UIN number, that is unique identification number, it was inadvertently mentioned as PAN number of Director of Messrs. Quicksoft Solutions Private Limited. This is petitioner before your lordship in bank guarantee application vice Sri Samar Sarlal Saha, which was rectified instantly once it was brought to our notice, and we have amended all the EPBGs and updated on the NESL, that is National E-Governance Services Limited, which they say with the correct UIN number of the client. Hope you must have received the same. Now, your lordship, it is a very defect from the side of the bank that the EPBGs they have uploaded, they have committed some mistake in uploading the UIN number, unique identification number, because it is a new system they are doing. Since February 2021, this was introduced, even the banks were new to this system. Now, when they say that EPBGs in NESL portal were not found, the bank immediately rectified its mistake, and all the bank guarantees I have given, they have uploaded it, your lordship. This is the reply given by the bank. After this, your lordship, nothing remains. No fault at all from my side, and no question of getting even a single rupee of advantage by making anything wrong, even a false statement or making anything wrong statement. Your lordship, may kindly see, and thereafter they are imposing a penalty that I will be debarred from 2 years for a period of 2 years from participating. Your Lordship may kindly see that there is no fault attributable to the petitioner at all.
All right. Yes, Mr. Mish.
My
Your
lord,
opinion.
Lordship kindly see page 17, that is show cause notice. We have issued the show cause notice and relevant Lordship kindly
Have
page
you
19.
taken into account that communication from the bank?
Lordship kindly see page 19 for a moment, my lord. Page 19, my lord, we have written that it appears that Messrs. Quick Soft Solution Private Limited has used the PAN number such and such of one of their director, Mr. Shah, instead of the beneficiary PAN number, my lord. Because here is the petitioner is Quick Soft Solution Private Limited, the company, and the company has the PAN number. Without using the company PAN number, he has used the PAN number one of his director, my lord. Then we have written that which violates the amended rule of 171 of General Finance Rules 2017, thus depriving the beneficiary Odisha Police from availing due performance of the contract. If EPBG were not reflected in the NESL portal, they were not issued by the issuing bank and digital signature were forged. Digital signature were forged. This is the so-called, and there was every risk of invoking the EPBG by Mr. Samar Serial Saha, in whose PAN number, card number, the BG was issued. And the Odisha police did not have any control of BG, which could have been compromised execution of the contract.
Yes.
My lord, that is not the case, your lordship. I have not misutilized it, your lordship. I have given the bank guarantee. It is wrong from the side of the bank that they have inadvertently put my PAN number.
That we have understood. That is one of the points.
My lord.
What about forging the signature?
Absolutely not, my lord. With respect, my lord, there is absolutely no forgery of signature. If they can produce any signature which is forged, I have got nothing to say. Absolutely, my lord, nothing. This is simple statement they are making. And the only allegation, even if your lordship may see that, the bank guarantees are valid even for a period of 1 year.
Let the affidavit come.
My lord. My lord.
And if the allegations were so serious,
My lord.
why for 2 years?
Yes, your lordship.
Why, if the allegations are of...
Normally, the OPD code is specified that minimum 3 years.
No, it is a maximum 2 years.
Maximum.
Max.
So why 2 years?
Why only 2 years?
My lord.
Why 2 years?
My lord.
Maximum.
My lord.
And in the
Confined to 3 years, my lord. Maximum 5 years. Maximum 5 years. I'll take care.
Don't
Universal answers.
To give us an affidavit.
My lord, I will give them.
How much time? 4 weeks?
4 weeks, my lord. Because this has been done delivered, my lord. Because this is a performance bank guarantee.
All it will.
When will invoke, then he will raise that I have not issued that.
My lord, I am on item 16. I could not reach out to your lordship's lord.
All right.
Yeah, bank is a...
Bank is a party. I have made a bank pro forma opposite party, your
All
lordship.
right.
My lord. Because I have no prayer against bank.
All right.
My lord.
My lord, I am on item 16. I could not reach your lordship's, my lord. I was submitting, but I was not audible. So may kindly be taken up after lunch, my lords. Item 16, my lords.
It will come on Monday. Yes.
My lord, in item 17, may I serve extra amendment, your lordship?
My lord, let it.
My lord, I'll
Next
serve.
item 18. Your lordship take up or
After lunch?
your lordship sitting after lunch.
Is there any prohibition?
No, my lord.
I don't know.
All right. So what is there in item number 18?
18.
We can finish.
How we can? Yes, yes.
18, my lord?
18.
But item 18, actually, I have filed an application for leave, number 1. That is at Rule 8 of the Odisha High Court Public Interest Litigation Rules, that it requires that notice has to be given in compliance to Section 80 CPC. I have given the notice, Annexure 3, but I can't wait for 60 days. So they have sought for the leave and filed this application. This is regarding this health sector matter. The safety and the health of the people, particularly the pregnant women and children. This is a supply of long-lasting insecticide evaluated mosquito nets. This LLIC, these nets are specifically manufactured with a particular brand of insecticide, that's a delta methadone, to prevent mosquitoes or repel mosquitoes not to come near.
So you are presenting whom, the petitioner or the
No,
The no way related to that, my lord. So actually, there's just
No, I'm sorry, you've been repeating pregnant word many times.
Right.
Does it have any other significance or only the mosquito net?
mosquito net.
Okay.
yes.
Actually, government Orissa actually wanted to purchase 87 lakhs to supply to different parts of interior parts of like Koraput, Keonjhar, Mayurbhanj, where the villagers, particularly pregnant women and children, are to be protected. But this, when the notification was issued, a lot of people actually apply for the tender. One of the companies, opposite party number 7. But if you utilize this delta methadone, you have to get a registration certificate from the Insecticide Act. Section 9 provides that they must examine whether actually you come within the purview of that, whether it is harmful to the human safety and body health. So a registration certificate was granted, but it was noticed at a later stage that the certificate that is granted is a faulty one because they have not complied with ICMR, SOP and the provisions. So they have kept it on a hold, registration certificate. That was challenged in Madurai bench, Madras High Court. There actually one of the ground taken is I have to participate in the tender floated by government of Orissa.
Who has to participate?
OP number 7.
So you said I.
No, sir. This OP number 7 was to participate in the tender process. Therefore, this keeping the registration on hold will create an embargo. And an interim order was passed there. Odisha government was not made a party. And order was passed that in spite of the hold, there is no bar to participate. So we participate in the tender.
Again.
Government of Orissa. So I am no way concerned about it. I only relate to safety part. The petitioner doesn't have anything, he's an NGO. He only wants that that matter is still pending. Inquiry is going on. The registration is kept on hold. In the meantime, the allotment has been made. 3 persons have been given allotment of different 58 lakhs. 18 lakhs have been asked him to supply. If he supplies and utilized before it is tested chemically, whether it is fit to be used, it will be harmful to the person who use it. The limited prayer is till the inquiry is conducted by the registration committee as per the statute, this supply of material should not be utilized or should be kept abeyance. I don't have any grievance if it supplies. Try to look at section 9.
Section 9 of?
Sir, insecticide tax, I'm giving copies, my lord. I have also annexed it. It's a health hazard, in fact.
Page 80 is that.
Yes. Write it.
Page 85 dollars.
Section?
Section 9, my lord.
Yes.
Registration insecticides. Any person desiring to import or manufacture any insecticide may apply to the registration committee for registration of such insecticide, shall have a separate application for each insecticide, provided that any person engaged in business of import and manufacture of insecticide immediately before the commencement of this section shall make an application to the registration committee within a period of 7 months from the date of such commencement of registration of the insecticides, which he has been importing or manufacturing before that date. Provided further that where any person referred to in preceding proviso fails to make an application of this proviso within the period specified, he may make such application at the time thereof and payment of penalty of 100 rupees for every month or part thereof after the expiry of such period for registration of each such insecticide. Every application shall be in such form and contain such particular as may be prescribed. 3 says, on receipt of any such application for registration of an insecticide, the committee may, after such inquiry as it deems fit, after satisfying itself that the insecticide to which the application relates conform to the claim made by the importers or to the manufacturer, as the case may be, as regards the efficacy of insecticide and its safety to human beings and animal, register on such condition as may be specified on payment of such fee as may be prescribed, the insecticides allot a registration number and issue a certificate of registration in token thereof within a period of 12 months from the date of such receipt of the application. But 3C may kindly be seen. The registering committee may, having regard to the efficacy of the insecticides and safety to human being and animal, vary conditions subject to which the certificate of registration has been granted, may for that purpose require certificate holder to note by notice in writing to deliver the certificate within a time as may be specified in notice. They have issued a notice to them. We are keeping it on hold. Therefore, the certificate issued has been kept on hold. If a lordship looks at that, order is also have annexed.
Again, we.
No,
Registration committee. The
Who has kept it in?
registering authority. They have kept the registration certificate on hold. That was challenged before the Madurai bench.
So registration committee
Yes.
authority
Yes. Registration committee.
of Odisha,
No. It's all India business.
it's all India.
Registration.
They have kept it on hold. It's still in hold. It has not been cleared. And he has been allowed to participate in the tender. No difficulty, my lord. Can participate. But supply part, where the mosquito net which is utilized by the insecticide, unless it is tested and cleared by the authority, as per the ICR guideline, and the SOP issued by the ICR, it cannot be utilized. Cannot be used by human.
So one thing from the reading, I may be wrong, but from a reading of that provision,
Right.
it says manufacturer or import for import.
Right. He is a manufacturer.
The another manufacturer who has the
No,
registration.
here he is
certificate.
the manufacturer. Therefore, he applied for license.
Manufacturer of the net,
Date.
but the insecticide can be procured from
No,
another.
procured is
manufacturer.
utilized for preparation of the net.
Exactly, that insecticide.
So what is the
can
tender?
procure-
What is the tender? What is the notice, tender notice?
Tender
Where is the
notice
work
is
order?
for supply of long LLIC. This is the long-lasting impregnated mosquito nets.
All right, but that the respondent number 7 is participating.
Yes, he has participated. He has been accepted and given the order for supply of 18 lakhs of mosquito nets. I don't have any grievance, my lord. 3 persons have been given different parts. He can give. But his registration certificate is on hold. Unless that is clear, it should not be utilized. Because they have the authority to say it is usable or not. Because the percentage of insecticide is to be utilized. It cannot be higher than that which is poisonous.
There must be someone for the Union of India.
Yes, yes.
Not with them.
Have you served?
Yes.
Yes.
Someone is appearing.
So the prohibition part, section 18, let's me kindly see that act. Section 18 says.
We shall take up the matter on Monday, Mr. Mishra.
Monday, yes. 30 years, that's exactly.
And in the meanwhile, just let us see where
That
is
is
the
a-
notice.
So Odisha Medical Health Corporation.
Corporation
Odisha.
will appear. and
So
also-
you are
is the
appearing.
wing of the state.
No, they've got a not
They have a
different
panel.
So state
they've
is a
got a
party.
panel.
Health department is a
4 to
party.
5% they appear. Mr.
No, no.
Tripathi, Mr.
The
Murli.
OMSC or
Odisha Medical Council, members. Odisha State Medical Corporation.
We have no grievance, anybody who is alerted. But it must
Corporation
be
had
as
floated
per
the
statute.
tender and asked for those bloods. Corporation had floated the tender for procurement of those net
And
bloods.
interestingly,
but finally they will be supplying to you. And
Yes.
you will be supplying to people.
Right,
So
boss.
Everyone's interest is involved.
No, I don't dispute that. No.
Safety of the people is.
You may also take a stand.
Yes, yes, yes.
We'll take up this matter on Monday.
Right.
Meanwhile, please inform and counsel for the corporation and Union of India.
One more thing, sir. Of course, I'm not sure whether mosquito nets will come within the definition of insecticides, because
No, it is actually
Insecticides are
scheduled.
being used in the mosquito nets.
right, that is not.
No,
Therefore,
my
the
query
mosquito
was-
nets are such that the mosquitoes will not touch the mosquito
Yes,
nets.
yes, yes.
Right, no. They will repel from this nets,
Right.
once it is
So
used,
they
the
will be
chemical that
using
is used in the
repellents
nets. That I
also.
understand. No.
Correct.
That you have those mosquito patches also. So
And
this
that
is a
chemical
bigger-
component is a part of the schedule as per the Insecticides Act.
My query is, what you showed us in that provision,
Right.
that for import and manufacture.
Manufacture.
But I don't know what is your case. It may also be that they may have obtained the insecticides from a registered manufacturer.
So they are actually, he himself has applied for license, for registration.
No.
Suppose he doesn't get the license to do the work, till the license comes, he can get it from there may be loss of profit. He can get it from a
Other
registered
manufacturer having registered.
You can do it, but well,
Yes.
I have no grievance against individual.
No, exactly. So just examine if that
Yes.
question arises, that
We are only saying safety of the people.
he may not be able to manufacture until he gets the registration
Correct.
certificate, but he can get it from a
Yes,
manufacturer.
All that we will see.
Yes, ma'am, Monday.
So just check it out. Yeah, but-
Only one or two matters.
2 matters, yes.
Item 19.
I'm going to think.
19 though, I think I've seen that.
My lord, the matter with the non-issuance of certificate, MBA certificate. Non-issuance of a MBA certificate.
Which certificate?
Passed the.
Master of Business
2008
Administration, MBA, Millers.
MBA, Master in Business Administration.
Which university?
Passed in the 2018.
Which university?
BPUT, Business, Biju Patna University of Technology.
So you passed in 2008.
Yes.
18, 16 to 18.
18.
2018. 18, sir.
18.
Lord.
Why have you come in 2024?
Back to the first.
2018.
Why have you come in 2024? You passed in 2018.
Already 6 years passed at college. College, I have applied gradually to college, issue my certificate, but they are not listening. They are not send my mark sheet to the BPUT.
Why?
So that the BPUT was not issue my certificate. So that I request you kindly, my lord, I have already passed 6 years, so that I request you kindly give a direction to the BPUT to issue my certificate. Neither my life is going to spoil.
So Jenna, one moment, please. You had earlier approached this court.
Yes.
Court had asked you to file a representation. So they have disposed of, saying that we don't know what is your case, so give us some additional documents.
Yes.
Now, have you given them additional documents or you have approached this court?
Annexure.
Annexure 4 is
4,
the letter.
page number 18 and 19, the college has already
representation is
college has
disposed
admitted. I have submitted all the documents to the BPUT.
So that has been disposed of.
But the institution says since 2022, they have sent the marks of the present petitioner for publication of result. That is the representation which has been disclosed of, they disclosed in that representation, not disposal order.
If he has not been issued certificate, just see to it. Who do you represent?
No, BPUT, not they've got a different.
Mr. Satpathy or who appears?
I'll find out. Mr. Mahapatra was previously now before becoming a judge of the Civil Court. Thereafter, Mr. Palit is appearing in some cases where he is the senior counsel.
Ask him.
I'll find out who will appear for them. I'll find
Monday.
So that he'll have a copy.
Yes, on Monday let it be taken up. I will find out who will appear for them.
Item 20.
Please, Your Lordship. Let here the petition challenging the blacklisting order of 3 years. Let the on 7/9/2022 as well as the 15/9/2022, the authority passed 2 orders, chief engineer and the superintendent engineer, that the non-deposit of FPS, your tender is cancelled. Thereafter, no action will be, no correspondence will be made. My lord. After 1 year, this letter, they behind back on 13/11/2010, they blacklisted me. My lord. But a single, my lord, my humble summons is once you issue the order that no correspondence will be made in this regard, and since the tender is cancelled, you cannot behind back without any specific show cause notice blacklist me.
So no notice was issued.
No, my lord. Specific show cause notice not issued.
I'll take instruction, ma'am.
While cancelling, they had said further proceeding shall be initiated.
No, my lord. Thereafter, your lordship, phase 106. No.
Page 206.
Your
last
lordship.
line.
Phase 2, your lord, blacklist, phase 206, your lordship.
Yeah, last line.
Phase 2.
Further proceeding for blacklisting shall be initiated against as per amended dated so and so.
No, my lord. This is the clause, your lordship, quoted. Your lordship, next page is the last page. Page 207, your lordship. Therefore, the
Okay, okay. So
no
this, they
further.
just quoted without saying that
Exactly,
they are
my
going to
lord.
follow that. All right.
Yes, sir.
Yes, yes.
No, I'll file a counter.
Complex. Obliged.